Well, welcome to everyone that has joined in our session, and obviously we will have others joining us throughout the afternoon. I am Cindy Giordano. I'm Director of Marketing and Events for the Greater Conejo Valley Chamber of Commerce. We're very happy to have you all join us this morning, or I should say this afternoon, for our ADA compliance webinar. And before I introduce our president and CEO, I'd like to share with everybody, we do have our chat open so that everybody can put in their comments and their questions for our speaker today. So if you could all just note, I've opened it up so you can all see each other's chat submissions. So throughout the webinar this afternoon, we will be entertaining, our speaker will be entertaining questions and addressing those questions. What we'll do is our speaker will present for about 15 minutes, and then I will pull some of your questions and share them with Duncan, and then he'll go back into the presentation. So we'll have one or two of those Q&A sessions throughout the seminar, and then at the conclusion, with time, we'll be also entertaining some additional questions. And again, put them into chat, and we will go ahead and I'll take care of moderating and sharing those with Duncan throughout the webinar. So with that, I am very honored and very happy to introduce our president and CEO for the Greater Conejo Valley Chamber of Commerce, Ms. Danielle Borgia. Danielle?
Thank you, Cindy. Good afternoon, everyone. So our chamber knows that ADA compliance has been an area that has been impacting our local businesses. And we really see this webinar as an opportunity to convene our partners in the room and provide some education in this space. Last year, our chamber was heavily involved in advocating at the statewide level for some legislation that would have helped with some of these current challenges that we're facing, including serial litigants and creating, a cure time for small businesses prior to any lawsuits being served. Unfortunately, this legislation did not move forward, and I think why today's webinar is even more important than ever. So I'm really pleased to have a resident ADA expert in the house with us this afternoon in Duncan McKay, because this is certainly not my area of expertise. And so it's my pleasure to introduce Duncan to the group. He is a Class 1 DSA inspector, which I'm sure he'll tell us what that means. He's also licensed as a certified access specialist who works with contractors, architects, and property owners to make sure their projects meet all the standards required by the California Division of State Architect. As an independent contractor, licensed and insured, he also works on the design and installation of solar and solar battery systems. He collaborates with each client to ensure their needs are met, and all compliance and access issues are also current to standards. Nearly 2 decades as an engineer in the live television broadcast industry prepared him to think on his feet and find solutions rather than just identify problems. So at this time, I would like to turn it over to Duncan McKay.
Welcome, everybody. That was interesting. I think that was from my LinkedIn website, which somebody else wrote for me.
Hopefully it's all true.
Yeah, it's mostly true. So my claim to fame here is that I'm a certified access specialist. It was created 2008 under the Division of State Architect. Manages it. My number, certificate, not a license, I guess, but it's 416. I think the latest person to join the fold is like number 1248. There's probably, some people have dropped off. There's probably 1,000 active certified access specialists. Of those, about 600 work for city, county, etc. The building departments, and those are referred to as the AHJ, authority having jurisdiction. So we'll kind of pop on that later, and it's in a lot of the literature, the AHJ, authority having jurisdiction. So really there's 400 people like me out there trying to get things right and to help people not get in trouble. That's me. That's an old picture. So people who know me, we're on this now, will say, where's the gray hair? But I'm going to do this as a lightning round, quick review of accessibility regulations. There's some key things in it that do help you understand it, though. We use ADA as shorthand for accessibility, but there are layers to it. ADA is a federal law, 1990 ADA, Americans with Disabilities Act. And underneath that is ADA Title 1, 2, and 3, on 4 and 5 as well. But 1 is employment. We don't have anything to do with that. Anything back of the house is under a different criteria. 2 is public entities. That's all the city and state, how they're handling their, and county, how they're handling their roads and sidewalks, etc., and even mass transit. Title 3, that's what we're going to be talking about, public accommodations and commercial facilities. And when you say public accommodations, that's not public like the government, that's places that are open to the public. If you're a restaurant or retail store, just about any, hotels, motels, that's falls under public accommodations. Title 4 is telecommunications, and think websites. We're not going to delve into that. It is an entirely different quagmire. If you do want to look at website compliance, there are some tools that you can use to run your website through. They miss some of the things. University of Utah has a great program, and they're working on some of that stuff. So I'll try to put some links into, or give you some links to look at that if you're concerned about website. And then miscellaneous, so we won't worry about that. So 1990 ADA, it wasn't until 91 that they came out with the standards for accessible design. And then that was revised in 2010 to the 2010 standards for accessible design. All of that falls under the Department of Justice. And so they have ADA ADAG accessibility guidelines. And so well, it's written on paper, but here is how it actually gets executed. So before the ADA, way back in 1961, the American National Standard kind of took the first stab at it, and that was revised in 1980. ANS had become ANSI, Standards Institute, and the California Building Code, which is UBC, Universal Building Code, California, of course, that's not good enough for them, so we have California amendments on top of that. Starting in 1970, then 82, 86, 89, every 3 years, and then every 18 months in between those, they figure out what did we miss and where we could fix. So every 18 months it changes. Usually not that much. People complain about the standards changing, but usually it's small incremental things, and every once in a while they make a big leap that you have to adjust to. California passed the DPA, California Disabled Persons Act, 1968. And then, but prior to that, the Unruh Civil Rights Act. But that didn't deal with accessibility until 1991. It accepted the provisions of the 1990 ADA. And so that meant that a violation of the ADA was also a violation of the Unruh Civil Rights Act. And that really kicked things off in California. So your business can get sued under 3 different statutes, the ADA, and if you win in the ADA, or if the plaintiff wins, you have injunctive relief, meaning you've got to fix that stairs, ramp, sidewalk, etc. Do you get damages? No. If you win as a defendant, can you get your attorney's fees back? Yes. So that's a good thing. DPA, injunctive relief, yes. Damages, 3 times the damages, no less than $1,000. Can the defendant get his attorney fees paid? Yes. Under the Unruh Civil Rights Act, you can get injunctive relief and 3 times damages, no less than $4,000, and that's $4,000 per incident. So if there's a barrier, there's $4,000, and then they will also sue to say, I couldn't get access, and I suffered difficulty, discomfort, and embarrassment in trying to get past that barrier. So oftentimes it's $8,000 that they'll ask for damages, and often they'll find something else. So it can be $12,000. Can you, as a defendant, get your attorney's fee back if you win? No. So which one of those is a potential plaintiff going to pick? Well, this is taken out of a actual lawsuit recently. and they make a note, the plaintiff is not invoking Section 55 of the California Civil Code and not seeking injunctive relief under the Disabled Persons Act. So they want to make sure everybody knows, no, we're not getting involved in anything where we're going to have to pay your attorney's fees if we lose. And so now that kind of covered that, but everybody's question is, what rules and regulations apply to my business? And this is really the most important part of trying to figure out what your exposure is, what you can fix. Well, what regulations apply? Well, the applicable standards. So if you have a building that was built in X date, the date you got the permit, that's when that's the standard that applies. If you're doing an alteration, the date the permit was approved for the alteration, but just for that segment of the building or site that you're modifying. So if you put in a restroom, the rest of the facility doesn't have to come up. So you put in a restroom in 2000, your rest of your facility doesn't need to come up to the 2000 standards if it was pre-91. But your path to the altered portion of the site does need to get revised. So it gets interesting when you're trying to figure that out. If you didn't get a permit, say you just decided to put in a bathroom or widen a door or put in a ramp, if you didn't get a permit, then the date that you actually performed the construction, that's what applies. And you're going to apply the standards based on, the dates that you see on the chart. Accessibility in the California Building Code breaks down to Chapter 11B, which is for commercial applications, and Chapter 11A for publicly financed housing. FHA, a lot of different variations on that. It may be that just a small segment of the project was under that, but they may want to apply 11A to that. That is beyond the scope of what we're going to talk about, and I am not a specialist in FHA, publicly financed properties, etc. So I'm going to stay out of that. So everyone says, my property was built before 1991 and I'm grandfathered. And it's like, grandfather doesn't mean anything. It means your father's father, but it doesn't mean anything in this application. There is a term, safe harbor. If it was built before 1991, you do get some protections in saying we're going to apply these standards, but you have some other obligations. You have an obligation to maintain elements in working order. Alterations, like I said before, are going to trigger a new applicable standard. And this is the big one. And it requires knowledge of when modifications occurred and a bunch of things, but you have a continuous obligation for readily achievable barrier removal. And so there's a list of things, and we're going to click those real quick, but that's really important to look at what the readily achievable barriers. So now we look at the definition. No, here's the items that are considered readily achievable barrier removals: and installing ramps, making curb cuts, repositioning shelves, rearranging tables. Rearranging tables is a big thing in restaurants because you're trying to pack as many people as you can, but the night shift comes in and cleans and moves things around. You need to make sure that the accessible tables are always accessible. And I'm going to do some links to checklists that help you, evaluate your own facility. Repositioning telephones. I always laugh about that. It's like, well, we want to make sure that your butter churn is also accessible. I saw a payphone for the first time in years in a Napa Auto Parts store, and it didn't work, and there were boxes piled in front of me, but it was like, I wanted to bring my children and show them that. Adding raised markings on elevator control buttons, installing flashing alarm lights. This is actually a big, if you have fire alarms and they don't have the strobes, those people who have a hearing disability, that's one of the, a surprisingly large number of lawsuits are brought over that. Installing offset hinges to widen doorways. I'll touch on that in a minute. Eliminating a turnstile to provide an alternative accessible path. I haven't seen a turnstile in a long time, but alternative accessible paths. Installing accessible door hardware. So I always say if you put on oven mitts and try to operate the door, the hardware, anything you have in your facility, you can't do with an oven mitt on, it's not accessible. And that's readily achievable. It's relatively inexpensive, so that's a good self-test. Installing grab bars in toilet stalls, rearranging toilet partitions to increase maneuvering space. I did this at a facility recently. The architect had called for this complete refab, and I went in with the contractor, and we slid a couple of partitions around. It took us 2 hours, and it was compliant. Saved $20,000 or $30,000. Pretty amazing. Insulating lavatory pipes under sinks to prevent burns. We don't think about this, but if you were running hot water and the drain, it gets really hot. And a lot of people in wheelchairs, they might not have any sensation in their legs. So you can have your knee up against that for the whole time and suffer a burn that you don't even know about. Also applies to sharp objects under the sink. Install a raised toilet seat. Toilet seats have to be 17 to 19 inches. If you got a 15-inch, there are raised toilet seats that you just bolt on and can cover that. I don't recommend them. They don't last very long. They get so they slide around. Installing full-length mirror in a bathroom. The mirror above the sink needs to be a certain height, and if it's not, and you can't lower the sink has a backsplash, we'll put another full-length mirror on another wall. I think the bottom of that has to be 16 inches. Check. Paper towel dispensers, creating designated accessible parking spaces. Here's the big one. So even if you didn't have, if your facility was built before 1990, you're supposed to put in, if you can afford it, an accessible parking space. And then now you've got something new that's right out front, and it has to be compliant. And that's going to be a big target. Installing an accessible paper cup dispenser at an existing inaccessible water fountain. That's fine. That gets you by, but who's going to be filling the cup and keep making sure that that cup dispenser is filled? Removing high pile, low density carping. Borrow a wheelchair if you can and go around your facility, and you'd be so surprised at how tough it is to get through high pile carpeting. And installing vehicle hand controls. I was trying to think of an application where you would have different vehicle hand controls, and all I could think of was the bumper cars at a if barrier removal is not readily achievable, goods and services must be provided by alternative means. One of the examples in the DOJ is if you have a pharmacy and there's a flight of stairs up to it, you can do that by offering home delivery or delivery to the sidewalk. Well, you can offer that, but you got to have signage, and there's got to be a procedure. So I'll show you that in a minute. So this is a facility in a neighboring city, and it was a bar restaurant combination. This, you can see my cursor. Oh, I can't cursor here. How come? The right-hand portion in front of the door was, oh, there we go. This is at a steep slope, like 10%. The area in front of the door has to be flat, 2% or less. And they got sued, and I went and did the evaluation. And at the very end, I looked here, and behind, I moved the potted plant from the picture, but behind there was a button, and there was the ISA, International Symbol of Accessibility, little wheelchair. 5 years before, the previous tenant had moved out. They had installed this, and it was attached to there was a flashing light behind the bar and an audible tone. And that's how they dealt with alternative means. Oh, and I showed the top, $12,000 settlement and $40,000 in construction cost. I dealt with the city. This was a historic area and it had beautiful pavers. It was quite the deal to try to get this fixed, and he might have slipped by if he had just had that button visible. So here's lawyer wiggly room. How do you determine if a barrier is readily achievable? I wish there was real hard and fast guidance, but there's not. It's on a case-by-case basis, based on the nature and cost of barrier removal and the overall financial resource of the site or sites involved, including the number of persons employed, the effect on expenses and resources, legitimate safety requirements. This is, sometimes you need to have the push bar for a barrier for egress, but at night when you lock up your gates, you can't have somebody just reaching over and hit that bar. So, they make accommodation for that. Any other impact or action on the operation of the site, geographic separateness, and the administrative or fiscal relationship with the site or sites to a parent company or corporation. So if you're the local branch of a big operation, it's not your financial ability that's really going to determine whether it's readily achievable. You got to look at the whole umbrella. So that's really fuzzy. So my recommendation is just do everything you possibly can that's achievable. And some of it is so easy, changing the doorknobs and moving things. It's really a crime if you don't do, the easy stuff. And what's considered readily achievable can change over time. Regularly assess what you can do to improve accessibility. Every New Year's, walk around and see what you can do. Every presidential election, do a real hard and fast one, and maybe have some money allocated to do what's now readily achievable. And if you win the lottery, or maybe your business is incredibly successful, which I'm hoping for all of you, more things are achievable and readily achievable if you've got deep pockets. And technological changes. I talked to somebody recently, said, oh yeah, we're looking at cameras. We can identify what's going on, and using AI, figure out when somebody needs help and alert. So that, technologically, that could be a big difference in a few years.
Duncan, are you good?
Yep. Let's see questions.
Take one or two questions.
Sure.
So the first one we had was someone was asking again about the website compliance, and you shared that you would be at the end, you'll be providing some resources or resource links to those that know best with regards to that. So if you could just share quickly about that.
There's a lot of it's a cottage industry of people suing websites, and another cottage for people trying to help you. There are software applications and widgets that you can use to evaluate your website. There's holes in them, and so I really recommend getting somebody to go through and look at it from the point of view of somebody with vision impairment. As I said, University of Utah has some great stuff. I'll put that link on, and a lot of it's about contrast. When I first made this PowerPoint, I realized, I went back and looked, and I said, oh, I've got some horrible contrast. I've got light green on dark green, that sort of thing. And it's also, you need a subscript that describes every photo. So if you can mouse over something and it tells you what to do. My website is right now just a landing page, because I was so worried I really need to go through it and fix all those, because sometimes the plaintiffs don't like me, so they might come and pick on my website. So we're working on that. Anything else on that?
And then we also had one of our guests submit and share that they were just sued by an individual who has apparently been going around suing other businesses. They made a payment as per their lawyer's direction.
Mm-hmm.
They're wondering, who should we call to inspect and let us know what modifications need to be done to avoid this from happening again? And how long do we have to complete these modifications?
All right, so I'm going to deal with that later, but I'm going to do a quick thing on it. Is do what your lawyer tells you to do. he might want to get a different lawyer who specializes in this. So to do the inspection, you want a CASP, Certified Access Specialist. It doesn't have to be me, and I'm really busy, so I might not be able to get to it quickly. There'll be a link to the list of certified access specialists. You pick one maybe with an 805 area code, and in the list it says whether or not they do inspections. So get a certified access specialist, do the inspection. You probably want to do the inspection to it's a CRASCA standard. I forget what the acronym stands for, but because if you do that, then you can become a qualified defendant. Well, if you do it beforehand, you get to be a qualified defendant. If you do the CRASCA inspection, that will help you. You're not going to end up in court. You're going to settle it. But the report details everything that needs to be fixed based on the applicable standards. And it may be, and rarely, and I'll get to that later, maybe you're not required to fix that. If it was if the applicable standards, if you met that from 1991 and the plaintiff has raised that issue, then you could come back with a report and say, no, I met applicable standards, and so I'm not. But the plaintiffs have gotten really good about only picking stuff that you're not going to be able to defend. So get a lawyer, get a specialist, get a certified access specialist to do the inspection. You can have up to 120 days to fix it. My recommendation is always start fixing it as soon as you can. If you do end up in front of a judge, you can, show that you've made the effort to, and could even argue that the case is moot. Doesn't happen very often, but it's worth a try. All right. Anything else?
We'll do one more question and then we'll go back.
Sure.
Continue on. And a follow-up question to that, why doesn't the building inspector who's make the businesses and or building owners aware of this as the next step before permits are actually even issued?
I mean, it depends on the nature of what you're doing with the alteration. I always said when I did other types of inspection that I would run into that often. They would say, I would point out a violation and not related to accessibility. And he would say, well, the city saw this and they approved it. Well, the typical city inspector is on site for 9 minutes. The typical inspectors also do not have, the depth of training and accessibility. And there are now the cities and counties, the AAHJ, they have some CASP qualified inspectors on the payroll, but they may not be the ones who are going out in the field every day and doing that. The cities are getting better. I really feel badly when I go and see brand new work that has been permitted and it doesn't comply. But the cities are getting better at it. And during the permitting process, I see the cities bring it up a lot. I get in arguments with cities all the time, and people bring me in to try to convince the city that they're wrong, usually because the city is being is holding them to too high a standard based on what it is. So I wish there was more.
All right, well, let's go. We'll continue on and then we'll entertain another session in just a few minutes.
If you do an alteration, so this is going to be something that you negotiate with the city as you're going into it. If you're doing an alteration, and you're going to spend $100,000 on the alteration, then you're going to have to spend up to $20,000 to fix access compliance issues. So, and skip the first part of that. That's projects below the valuation threshold. So the threshold was $50,000 in 1981, and now the number's $200,000. So let's say you're under $200,000, you're going to have to spend 20% of that 100,000 construction costs, you're going to spend 20 grand, up to 20 grand fixing things. So you're doing a remodel in the building. You got a $20,000 potential budget to fix alterations, and you put in the ramp and there's nothing else, and you spent 6,000 on that. You don't need to spend the rest of the 20 grand. So you got 14,000 you could spend on something else. If the project is over a threshold, there isn't a limit. You're going to have to build it to current standards. So if it's a $300,000 project, you're going to build like it's brand new construction. They're going to make you do everything. And that's where the city does, in my experience, get deeply involved in the accessibility issues. And so it shouldn't be a surprise when you're finished with that. Priority for barrier removal. So if you got your 20, maybe you have your $20,000 budget, but you got $30,000 worth of accessibility work that needs to be done. So you got the priorities. One is accessible approach and entrance. And this also includes parking. So in parking, the path from parking to your front door. Priority 2, access to goods and services. So, all the inside stuff. And priority 3, access to restrooms. Priority 4, any other measures such as drinking fountains and public telephones again. So, if you spend your whole 20 grand doing parking and your access to your front door, maybe from the public right away, so you're done. So you don't have to go on to priority 2 and 3 and 4. What are the most common issues for an accessibility lawsuit? The California Commission on Disabled Access, their top 10, and it's kind of interesting the way they mixed it up, but non-compliant parking, path of travel, exterior, from parking and right away. You see all that, but I broke it down because of all the combinations. See the last one, parking insufficient number, I put that under parking. So here's my take on it. Various parking violations, 34%. Path of travel to and through your front door, 31%. So that's 65% of all of the accessibility lawsuits. And this was January 1 to June 31st, 2022. There were 2,529 cases. So that works out to 400 a month. And the other issues were access to goods and services and path of travel interior, which kind of the same thing. So that's 80%. I don't know what the other 20%, little chunk of that was the visual devices for fire alarms. But here, this is the bulk of what is causing the problems. Moving on. So here's a quick aside. So if you're going to go and look at your facility, or maybe you're going to do some work with an architect or a contractor, I see this problem all the time. Dimensions and measurements are usually a minimum or a maximum and not a target. So the architect will put, your slope in front of the door not to exceed 2%. And the contractor is going to read the plans and he's going to see 2%. So architects are getting better. So sometimes they'll put 1.9%, but by the time they're finishing the concrete, some areas of it are 1.6%, some are 2.2%, and the plaintiff is going to stick his level where it's 2.2%, take a photo and send you a lawsuit. If the plans say a parking space should be 9 foot wide, but it's centered of stripe to center of stripe, you might get 8'11", or you might get 9 feet to the outside because he didn't read all the way through it. If you install a sign, the parking sign particularly, at 80 inches, it says 80 inches minimum, but 90% of them I see are at 80 inches dead on. And then 5 years later, you resurface the parking lot and with another inch or two of asphalt, and your sign is at 78 inches. And the 80 inches minimum is a Basketball Player Protection Act, because if you're 6'8", you're going to hit your head on that, put a big gash in it, or at least knock your hat off. So I listed that stuff before. Try to fix what you can. Everybody's heard the story of the two guys hiking through Yosemite, and they come to a stream and they take their shoes off to ford the stream, and then they see a bear starts following him. One guy stops and sits on a log and starts putting on his shoes, and the other guy says, you're not going to be able to outrun the bear. And he says, I don't have to outrun the bear, I just have to outrun you. And so in the same way, when I walk down the street or even driving, I can see ADA violations everywhere. There's an infinite supply. If you're a plaintiff, you don't have to work very hard. So if you want to start by getting the low-hanging fruit that you can easily fix, and the stuff that's in front of your building, in front of the door. If you can do that, you've decreased your chances of getting sued by maybe 60%. So what are those? Parking. I see more claims over parking than anything else. I think even more so than the CCDA statistics show. The 2% slope. So everywhere in the code, it's saying that it needs to be level. Well, not really level. It needs to be level is anything less than 2%. And technically it's 2.08% because it comes from old engineering stuff that was a 1/4 inch per foot. So you divide 1 into 48, 1 inch in 4 feet, and you come up with 2.08. And it's percent, not degrees. I had a client call me up. I had done the inspection, and the lawyer said, I said his parking space had an area where it was 3%. And the lawyer sent photos of the plaintiff's complaint, and he had gotten out of the car and put his level down. And he said, no, this is a scam. They doctored the photos. I've got it right here. It's only 1.7%. And I said, is it in degrees or percent? He said, I don't think I have degrees on. So I drove back out there, and he had a level, and it was in degrees. So he was very disappointed and a little embarrassed. And it applies to the entire area, the parking space and the access aisle. So you look everywhere on it, and tire depressions are a big thing. It's really easy to take a nice new asphalt parking and you park a Arrowhead water truck on it for a couple of hours in 100-degree heat, and now you've got a big divot where the wheel was. Use a 2-foot long level. The contractor who comes to do it is going to want to use a 4-foot level because it evens out the bumps. The plaintiff is going to use a 1-foot level because you can pick up more sensitive indications of slope error. Use a 2-foot level. In the legal world, 2-foot seems to be the accepted one. There's a case, San Francisco and City of San Francisco versus somebody. I read the thing, it's 50 pages, and I couldn't find where it says 2-foot level. But that's generally accepted where it's come down to it. 2-foot will get you a long ways. So design for 1.5% max, and tell your contractor that that is your standard and you're not going to accept anything less. And so if you can get 1.5, you're going to, beat anybody with a 2-foot level, and it's likely to stay compliant longer. Do concrete if you can afford it. Probably costs twice as much, but 20 years later, it's still likely to be compliant. And the asphalt, it's tough on asphalt, all the traffic and heat. So this was about a 5-year-old spot. It had been redone. You can see where the new pavement was, this perimeter, and it was all really nicely done. But in 5 years, here's a depression right there. And, maybe the asphalt was a little soft, maybe early on. And this is where somebody will turn their tire right and left as they're maneuvering, and it digs a hole in it. And now you're not compliant. Tree roots. There's a tree right there. The root came through, 6.5%. You can grind those, but just check your whole area. If you want to do it yourself. So these are all digital levels. The top one is a 1-foot long level. maybe it's 11 inches. But you can stack it on top of a 2-foot level. And the top one's $69. The middle one's $120. The bottom one is my $300 German Stabilo level. I fought it for a long time. I said, no, mine are just as good. And then I got in a dispute with the contractor, and he had a Stabilo level, and he was a 10th better. So he met the standard. I didn't. I went I I always calibrate them. If you get a reading that's just a little bit over 2.1 instead of 2.0, you flip the level around, do another measurement, and you average the two. I mean, you know, a 1/10 of a percent is the thickness of a paperclip at the end of your level, so it's very critical. So I finally gave in and bought the German level, and they were right. Passenger car space dimensions. Dimensions is probably the next thing, maybe. Measure center to stripe, like I said, 9 feet wide and 18 feet long. Aisle is 5 feet wide, and for a passenger space, it can be on either side of the space. Aisles run full length of the accessible space, and there's a big problem. Somebody will have a space that's the right length, but the access aisle is a foot short in the front because there's a planter that curb sticks out. So you see that a lot. Here you see the van space is 12 foot wide, 5-foot aisle, and 9-foot wide car space. This is a really common van spaces, but in the aisle always needs to be on the passenger side. I saw brand new, somebody did it, and they put the access aisle on and like I said, you can see that from the street, and plaintiff will do a U-turn and come and get you. Special trick, a van space could be 9 feet wide if the aisle is 8 feet wide. And I use this a lot. They'll say, it can't be done, I don't have space. Well, yes, you do. If you make your aisle 8 feet wide, now you've gotten out beyond an obstruction. Your 9-foot wide aisle is great. It also allows people, it makes it easier to, they could drive over that to get to the adjacent parking space. Either way, combined width is 17. And so diagonal spaces, you see these a lot, but I'm always surprised when somebody does it right. It's so rare because you need to have the access aisle needs to run the full length of the parking space. So this does this. One thing about this, especially if there's multiple spaces, accessible, is it pushes you way out into the drive aisle, and people are reluctant to do that because they want to have enough room for people to maneuver and for a fire lane, etc. This is what I see all the time. So this aisle or this parking space is 18 feet long here, but it's not there. So this space is this long here, but look, now the access aisle is, it's 25 feet long, but it's not the same length as the access aisle or as the parking space directly adjacent. So diagonal requires lots of extra care. If you got a facility and you walk outside, I'll give you 2-to-1 odds that your diagonal accessible parking space, if it's paired with another space, is not compliant. So you can do parallel accessible spaces, which are really rare. There's one in front of the CVS and Ralph's, I think. No, just the CVS on Moore Park and near Moore Park and Jan's. And it comes in really handy because they're only 17 feet wide. And so they could be in this area without protruding into the drive aisle. And I've recommended it several times. They're so rare that there's not even a diagram in the literature on them. You have to do it your own. So a lot of facilities have been striped with these double white lines. It makes you center your car so you don't park too close and ding the guy next door. Well, you make these accessible spaces, and the company that comes and paints the stripes just does this. Now this space isn't 9 feet wide to the center of this aisle. Now it's 8'6" wide or 8'8". I see that often. The accessible aisle, I think we went over that. There's 12-inch high, no parking, no detectable warnings. So detectable warnings have become a big deal. You know, the yellow dots, that's been coming into play a lot more. Architects will throw them in, but they throw them in at the into the access aisle. Blue border all the way around. It's like the stripers are saving their blue paint. It must be precious because they never get that right. So here's a nice, real pretty, almost correct thing that was done. This is a mall up north, Northern California. So they didn't stripe this side of the parking space, and they didn't. So you'd want it extended all the way out so it lines up with the end of the parking space. Here, again, it should have been striped. Otherwise, they're in pretty good shape. If this parking space down here was also an accessible space, you'd want to cut the, add striping to push this aisle out further. So, but it's so pretty that they probably wouldn't have, the plaintiff wouldn't have picked on it. This is what I was talking about, the detectable warnings, yellow, little dots. They used to be all kinds of colors. Now the requirements are, they have to be federal yellow. If you have, earth tone ones like they do in front of, I think, the Costco and Simi, you can replace them with up to 10, if 10% of them are damaged, you can replace them with the same color. Otherwise, it's all got to be new federal yellow, which is kind of ugly. Parking signs requires a tow-away sign at the entrance, or you can place it visible from all spaces. If you have a small place, you got 8 parking spaces, you can, and two accessible ones, you can put it kind of in front of them where everybody can see. If it's a van accessible space, you got to write van accessible. Every one of them has to have a $250 minimum fine, height of 80 inches minimum if it's on a circulation path. So circulation path is different from path of travel. It can be, anywhere that you can think that some pedestrian is going to walk, whether you want to or not, unless it's in a if it's on a post and it's in a planter or something, non-walkable, you can get away with lowering. Again, why not make it 84 inches instead of 81 or instead of 80? If it's on the wall in front or a fence or a post, it can be 60 inches high. You don't want them defaced or blocked by plants and faded, etc. So here they've got a tow-away sign, but it's the wrong dimension. There's specific dimensions in the code, and it has a phone number and who's doing the towing, but so it's good except for it's wrong. This is what it's supposed to be like, not with this, but this size. Here's a good one: unauthorized vehicles, blah blah blah, at owner's expense. It doesn't tell you. It doesn't tell you who the tow company is for you to call and put the number in. So you have to fill that in. Unlikely to get you sued, but it's nice. Like I say, if your facility looks compliant from the outside, they're not going to go hunting. This one is done right. There's lots of variations of this that all in one sign in this case with the van accessible. Technically, you're not even required for it to say parking only. Just the international sign of accessibility. Ran into that one time and I called it out, and then I did the research, and it was, well, nobody really tells you have to do that. Here we have punk rock band stickers on the sign, so we want to fix that. And bottom of the sign is at 68.5 inches. That 68.5, you don't need to be a basketball player. Anybody can scratch their head on that. So pretty blatant. Here we have the signs all covered by vegetation, something you can fix pretty easily. God, we're getting close to the end. Okay. Path to your door, 2% cross slope, 5% running slope, abrupt. So here there's 7.6%. Anything over 5% is a ramp. Ramps have to have handrails and landings at top and bottom. So you don't want to build ramps if you can avoid it. Here we have anything over a quarter of an inch, abrupt change in level. You can't have that unless you bevel it. 1/2 inch if it's beveled. And this will take your high heel shoe off real easily. So fill that in with something so it's not a hazard. Here's stairs that are done right. Exterior stairs, contrasting stripe on every tread. And you're used to seeing handrail extensions like this, but this is okay. You can have it just go straight to the ground. Big mistake on these is it says 12 inches. That's the horizontal portion before the curve. The purpose of this is if you're sight limited and you're coming down the stairs, when it changes to horizontal, it is a signal to you that you've reached the last step. And door to your business, 32-inch minimum clear. The bottom 10 inches need to be a smooth surface, so the wheelchair is not gonna, the guards on the foot guards aren't gonna hook on it. This is the strike side of the door. This is the hinge side. You need 24 inches out here that are level. It's a landing, less than 2% maneuvering space. So this whole area needs to be 2%. I got some more info there. Oh, needs to open 90 degrees. Needs to take 5 seconds to close from 90 to 12 degrees. Thresholds are a big thing. Make sure your threshold is less than 1/2 inch. Inside, pretty much the same. If you have a rug or a mat to wipe their feet on, make sure it's secured. And you still need this 24 inches clear at the strike side, so move the potted plant. These offset hinges can get you out of a lot of trouble. I sponsored doorcorner.com. You can get the hinges at another cast. Went to see a hotel and they had stored all the doors wrong and they were less than 30. They were 31 inches. It was going to cost him $200,000 to fix it. And so he flew out, saw him, said, put offset hinges in, and saved him a bundle of money. The interior path of travel is all about the aisles and the checkout counter. So don't store all the stuff in your aisles if you can. And your checkout counter, you need 34 max height, 36-inch length clear, and you're tempted to put stuff on it, but you can't. You got to keep it clear. Put a symbol here, international symbol of accessibility, and mark it off with tape or something. So, and train your employees not to fill it up with clutter. For side approach, I would move this rack over so that you can cruise up there in a wheelchair. If you're doing front approach, you'd have to have an opening underneath, and there's specs on that. Checkout aisles. So this has to be 34 if it's a checkout counter. Aisles is a different requirement. I don't know what a checkout aisle, I mean, you think of that as a grocery store. There's different requirements for width and height on that. They have check writing things. I don't know. You can argue with the judge whether it's a checkout aisle or a checkout counter. Reach ranges. Had a client who got sued because they had condiments up here and you were unable to reach over this to get to that. So bathrooms, there's too many items to list. I'll put a checklist on the information that you're going to get. It changes, over the years, it has changed so much that I really don't want to get into it. But what do I see the most? So this one is almost right. In fact, I think it is. The soap dispenser, these are too far to reach, but if you make this your accessible one down here, then you can reach that from where you want. And this is an office trailer that I was supplied for a contractor in the bathroom in there. I think everything is wrong. The grab bars are supposed to come out further. Here's a water heater under the sink. If you want to do it yourself, for $229, you can buy this handy template that gives you all the heights for toilets and everything. But you could also get it off the DSA website and then just trace it out on cardboard. So what do I do if I get sued? You get a lawyer, get a CASP inspection, and have a Construction Related Accessibility Standards Compliance Act conforming inspection done. Your lawyer's going to tell you, start fixing it right away. You document the existing conditions and then start fixing it. So by the time you get to, you say, hey, it's all fixed. Let's negotiate a lower cost. So if you have that inspection done, you can get this disability access and inspection certificate. That's going to give you some protection, let you know. You get a 120-day period where it can halt the discovery process, lower your legal fees, etc. If you get this done before you get sued, it does all kinds of things. And so if you have one of these, it's and an inspection report, the report is either going to say that your facility meets applicable standards, or it's going to say it was inspected by a CASP. And as part of that, you list the problems, and then you have you're going to have a schedule to remediate those. And you got to stick to that within 120 days. If you can go beyond 120 days if you have the permit and could show you're in the process. Here's a bunch of California legislation as things changed over time. Most recent one, high frequency litigants. These are guys who are going through town and causing all the havoc. If you've filed more than 10 suits in the last calendar year, you're a high frequency litigant, and they added $1,000 to their filing fee. Also requires them to supply you, when they give you the lawsuit, gives you a list of all the things that you can, all your rights and things you can do to defend it. So the end, the best defense. Who's seen the classic blockbuster 1983 movie War Games? So the only way to win is not to play. Greetings, Professor Falcon. Strange game. The only winning move is not to play. So I didn't get to all the questions. I'll stay around and answer questions for a while. If it's something I didn't answer or something that I don't know, or wasn't able to answer right now without the books in front of me, you can email me at, there's my email, duncangalt@yahoo.com. Please put chamber webinar in the subject line, and I know what it's about, and I will try to get to it and give you some more information. Try as hard as I can. Questions? I was lightning round to try to get through all that, so I don't hope I didn't speak too loudly and lose people.
We do have a couple of questions if you have a few minutes to.
Sure, I got all the time in the world.
Great. So one of the questions that came in is in regards to lease agreement documents. If lease agreement documents, the landlord is responsible for the outside and a lessee is responsible for the inside, including doors and windows, does liability apply, match this agreement?
So the interesting part is when you if you get sued, they're going to name people as defendants. They often name the the landlord and the tenant, and so and they'll name them both, and let the judge sort it out. If it's outside, typically, if the lease agreement says the landlord's responsible for the outside, you're probably okay. The landlords, from their point of view, they don't want to be responsible for the inside because you're going to put the condiments on a shelf that's too far away for them to be reachable. And so he's not responsible for those things that happen inside. Maybe responsible for the construction of the bathroom. There is recent legislation that clarifies CASP inspections and lease agreements, and it says that a tenant can request a CASP inspection, and the landlord has to allow that inspection to take place, and then you can include in the lease who's responsible for what. I think that's how it.
And then again, due to time, let's do one final question. One of our participants has asked if you could, Duncan, please repeat the most popular.
Yep.
lawsuits about ADA noncompliance.
Yep. Oh, didn't it be there? Oh, no, it's not. Here we go. This is California Commission on Disabled Access. Like I said, in the breakdown, it's that's confusing. So let's go to this breakdown. Parking, all the various elements of parking, 34%. Path of travel to and through your front door, 31%. Access to goods and services, 11%. Path of travel interior, 4%. Do you want to go back to the slide above that gives the other breakdown?
It would be summary, what the top 10 here, the most popular, I shouldn't say
Yeah.
popular, the most,
So that's my
the
summary.
top 10 list, yeah.
Yeah, there's the top 10 list. Non-compliant parking space. So that's covers a lot. Path of travel exterior from parking and the public right of way. Access to goods and services. But now we kind of repeat path of travel exterior vertical. Oh, that's stairs and elevators and ramp. I don't know, maybe ramps too. Parking, van accessible, or loading zone. So I just moved that into the non-compliant parking space. Path of travel exterior too far away, etc. I don't know how they broke that down. Parking signage, I put that up in parking. Path of travel interior, path of travel exterior, doors, thresholds, and handles. So I put that into the path of travel. Parking insufficient number. So I didn't show the graph, but basically the number of parking, if you have 25 or more parking, more than 25 parking spaces, you got to have 2 accessible spaces. And then if you get into the 50s and 100s are a little different rules, but I think most of us are just concerned about those 25 spaces. And that's how I broke it down.
Right, and one of our participants asked about, they're up in the Fresno area and they were asking about, how do they reach out to or find someone that they can contact in their area for the compliance.
Okay. Yeah, I'll put that on the links. If you go to, I wish I had it in front of me right now, but Division of the State Architect, find a CASP. If you type in those things, it should get you to the list. And so certified access specialist, it'll list the 1,200 of them. You find somebody that's got your area code, ideally, and you look and see if they do inspections, and you call, and if whoever you talk to, if they don't do it or they're retired, they can probably recommend somebody else.
And we just put
So-
that link into the chat for everyone.
Yeah.
So that they can see that. Wonderful. So again, thank you, Duncan, very much for
Sure.
your insight and all of the information. And again, if you could put your final slide back up so that everybody
Yep,
has your
yep,
email
yep.
address and contact information. So if there's
Okay.
anything that you have further questions about or need information about, please feel free to share that with Duncan. Oh, not your
My hummingbirds. Sorry, let's just go to the last one.
Yeah. And then make sure to put in the subject line chamber webinar so that Duncan
Yeah.
can then address those and provide links and
on.
any additional information or answer your questions.
Sorry,
We'll
giving
also
everybody.
be sharing those links and that information in follow-up to this webinar today.
Sorry.
I think that would work.
Sorry.
That's okay. And then as you're finding that, Duncan, there was one final question about the online
Sure.
compliance. So again, with the ADA online compliance, Duncan, you recommend?
Yeah. I want to, before I recommend something, I want to do a little more, just to make sure I'm not giving you
Perfect.
long
And then for
info.
everybody on screen that's still with us, thank you very much. His email address is there. It's duncangalt@yahoo.com. And again, please put chamber webinar in the subject line. Thank you all for attendance today. Really appreciate you, and hopefully you gained enough information to get you on your path and continue that dialogue with Duncan. So thank you. And if anybody else has any questions, please feel free to email us at the chamber and we will follow up with you post this webinar. Thank you all very much. Have a wonderful afternoon.
Thank you.